Mapp's Cleveland, Ohio home was entered by several police officers in search of gambling paraphernalia and a suspect in a bombing case who was alleged to be hiding there. They claimed to have a valid search warrant, but it was not produced during the search. While they didn't find what they were looking for, they did supposedly find obscene materials, and Mrs. Mapp was tried and convicted for possession of obscenity. While the trial judge acknowledged that the search was illegal, he admitted the evidence discovered, using as his reasoning a Supreme Court decision in Wolf v. Colorado in 1949, in which the court stated that the Weeks exclusionary rule did not apply to the states. Mrs. Mapp's attorneys originally appealed the case on the basis of the obscenity charges alone. However, when the American Civil Liberties Union filed an amicus curiae brief, it added that the abusive search procedure should also present an opportunity to review the Wolf decision, an opportunity it obviously felt would be well received by the court. In deciding for Mapp, the Supreme Court was able to reach a plurality decision on the outcome, but unable to present a majority opinion on the logic for reaching it. As such, while the Mapp decision is clear in its effect, that the Fourth Amendment, through the agency of the Due Process Clause of the 14th, requires all illegally gained evidence to be tossed out of state and federal court proceedings, the arguments supporting the outcome do not provide a lot of comfort that the court was clear in its constitutional vision. In his plurality opinion, Justice Tom Clark, who had always believed that Wolf would be found lacking, reiterated the arguments originally made in Weeks, pointing out Justice Oliver Wendell Holmes' opinion that without the exclusionary rule, the Fourth Amendment is reduced to a form of words. He responded to then-Judge Benjamin Nathan Cardozo's concern that a constable's blunder would set a criminal free, with the criminal goes free if he must, but it is the law that sets him free. Justice Potter Stewart, who had taken the position in an earlier case that the Due Process Clause of the 14th Amendment in and of itself should be sufficient to afford protection against illegal searches at the state level, would not join the opinion in Mapp because the exclusionary issue had not been properly briefed and argued in the case. Justice Hugo Black found himself as the swing vote in the case, but his was yet another line of logic. According to Justice Black, all evidence should be admitted at court, and offending police officers or detectives held accountable for their actions. He disagreed with the plurality assessment and opined that the exclusionary rule could only be justified by the Fourth and Fifth Amendments taken together. As a firm supporter of the incorporation doctrine, however, he agreed to apply the exclusionary rule to the states, but not with the logic that the plurality achieved in arriving there. Recently, there has been some turbulence in the criminal justice community to roll the exclusionary rule back under certain conditions, specifically as it regards the 1966 Miranda decision, regarding it as too much of an impediment to the pursuit of criminals. Thus, the Supreme Court has developed some exceptions to the exclusionary rule. How carefully the rollback is defined will, of course, determine whether it can pass constitutional muster. The court's legal logic today seems to be that it is foolish to punish the police for improperly gathering evidence rather than punishing the perpetrator of a crime.